Hey guys, sorry we're late. Omar was teabagging.
I was teabagging.
I
It was
don't know if
very, it
anyone
was
heard that
very
or not.
necessary. No, I had to get my vanilla energy tea going for it being
Yeah.
so late in the day after a very busy work week.
So you were teabagging.
Totally. With
People were asking,
a
is it
little bit of
7
honey.
p.m. PST? No, dude, we're just late. Sorry.
No, but this time it was my fault. Usually it's Lauren's fault. I'll take it. I
Well, it
will
was
take
my fault for
blame.
the first 5 minutes, but then when I got here late and you still weren't here, then I knew I was off the hook. So
I just want you to know I was debating whether or not to wear a shirt. I decided to wear one. I mean, like a
personally, I'm
nice
okay
shirt.
with No, personally, I'm okay with your choice not to show me your bare nipples, but I think everyone else might be a little disappointed.
Well, I didn't mean like that. I meant like never
Yeah,
mind.
okay, sure.
Anyway, we got this Me Too statute that is being hotly litigated. I will preview the issue because we had been talking about this months ago, and it was all the rage in the case about, first of all, is it even constitutional? Some say that it is.
Yeah.
I've, for Nora Pennington reasons, decided that it is not.
Uh-huh.
And then when do you impose the sanctions is the other issue that we didn't know about, because California is pretty silent. The statute itself is silent as to when do you oppose penalties. And then we decided that, well, we don't have to know. And so Lively in saying that they should be imposed at the earliest possible opportunity. Wayfarer partners are essentially saying that's nonsense. How could we possibly do that if she has to, at the very least, show that her claims are reasonable and without malice? That seems like a triable issue. There's no possible way you could award damages now without running afoul of some very major constitutional violations.
Yeah.
And so if we're going to deal with 47-1, you got to get over that issue. And then there is the jurisdictional issue, which I hadn't even thought about.
I still don't understand that still. So
it's basically this. If California doesn't allow people from other states, is what that word means, people from other states to take advantage of the laws that are in their state. In other words, if they wanted to do that, they would carve out a section for it in the statute. 47.1 does not. And there is at least one case that says that where a statute refuses or is silent on the issue of other states coming in and taking advantage of laws, then it doesn't exist. Therefore, if you reside in New York, then you shouldn't have access to 47.1, which is to avoid slick New York lawyers trying to take advantage of California's advantageous statutes with regard to people that file these SH claims. And then you say, well, wait a minute, she was able to file the CRD. Sure, but the CRD, I mean, it's not supposed to be the primary remedy for people suffering claims that Lively is asserting.
Right.
It's supposed to be able to be a mechanism to police employers and to give victims some kind of ability to have an independent investigation into these kinds of claims, to police it on their own. But it is not intended to be used from people that are from New York. Where the incident arose in New York.
She declined that investigation as well as any other investigation that was offered.
Yeah, because that was never the point. She doesn't need a free investigation. She has her own.
She doesn't want one.
And maybe she doesn't want one, right? But the point is that if just because you're able to file a CRD complaint should not give, according to Wayfarer parties, the opportunity to avail yourself of 47.1 if you're not a California resident, I guess, is basically the argument. So if that's the case, and it's not even their strongest argument, but if that's the case, then we don't even get to the merits of all the other stuff. And it eliminates the possibility of Lively's attorneys trying to slimily use 47.1 as a weapon against Wayfarer parties and Justin Baldoni.
I mean, it's pretty
that's my introduction into what I thought so far. I mean, amongst other things. I don't know. You talked about this last week. What did you think about it back then?
Well, the first point, like the big thing that stuck out to me was the declaration from the unnamed redacted whoever about Steve Sarowitz, when there was like, this is what your supporting kind of thing is. It's a declaration about something that happened A, on another project, B, did not involve sexual harassment, and C, was very vague. Like, there was just nothing I found that was really supportive of what she was saying here. She was basically just rehashing her complaint, and I felt like a lot of it was irrelevant.
Yeah, it was a rehashing. There wasn't a lot of substance. They were silent on a lot of the major key issues. She has to show, before we even get to any of their other arguments, that her claims were without malice and reasonable. She has to do those two things. And she really didn't do much other than she asserts that, well, the Wayfarer parties had malice in their hearts because Steve Sarowitz said that he has $100 billion or whatever he said.
I think that this would have been far more successful if she had just subpoenaed more people's bank accounts.
Why?
Dude, I'm being a dick.
Oh. Never mind. I was being too literal there. Never mind me.
You should never do that, dear.
I'm like, why? Man, I miss being the tilted lawyer sometimes. You know what I miss? I miss this case. I haven't talked about this case in, I feel like, months. I miss you. I miss Cassidy. I miss Lauren. I haven't spoken to Anita in months.
Oh, yeah. I haven't either, actually. Where is she?
I don't know. I miss all you guys, man.
I was like in and out traveling a lot, so I just lost touch with some people.
Well, that's not very nice.
I didn't do it on purpose, bro.
I mean, you never do.
No, I don't. Okay.
Should we get into these to this? So what was your plan? Did you want to read this word for word, or have you already
I've already done that. I've already done that. So no, let's go over your highlights.
All right, so yeah, I highlighted portions of this that I thought were important for some reason. So she starts and she's trying to frame it as the Wayfarer parties wanted to sue Lively into oblivion. The Steve Sarowitz threat to spend $100 million in litigation. The court has already punished the Wayfarer parties' pattern of using filings on the docket as an opportunity that has nothing to do with 47.1. That was basically gatekeeping for the docket. It has nothing to do with anything else. They're talking about their improper conduct, continuing. And then I circled this word reasonable basis because that's kind of what I had been saying months ago, that this all hinges, whether or not she could collect under 47.1 hinges on whether or not she can prove that there was a reasonable basis for her sexual harassment complaints. And as weak as her allegations are, I don't think that that's a slam dunk at all. Matter of fact, I think that it's more likely that a jury's going to find that it was not reasonable. She was just being a bit much.
You're missing the big picture. Somebody said that they had a negative experience with Justin Baldoni, and also people were saying mean things about her online.
Oh, well, if that's the case, then I will stay silent on that one. Yeah, I gotta be very careful nowadays. Anyway.
You do? Why?
Oh, because just because. The reasonable basis thing.
I'm sorry, that took me a minute to get that.
See, now you're being too literal. How about that? You were the one.
Yeah, but I don't like it when the roles are reversed, so move on.
Okay, so this reasonable basis thing, this was always going to be the biggest hurdle for her ability to collect. And then we've always wondered, like, how do they even litigate that? Do they just wait till the end of a trial and have a separate finding? In other words, like, what happens if she doesn't prevail on her sexual harassment claims? Does there then have to be a second finding? And who makes the finding? Is it the jury or is it the judge? We don't know, because 47.1 is silent as to that issue. But if you award fees right now, before that inquiry is even made, then what you're essentially asking a judge to do is make a determination about what's reasonable or not without hearing the evidence or without giving the opportunity to the other side to present evidence in the case that would go directly to the merits of this inquiry, which would make it unconstitutional and anti-SLAPP and all those things. And we'll get to that because Wayfarer brings it up. So that was the big question. They cite other stuff. The Wayfarer party suit is the prototypical suit that the California legislature intended to short circuit by enacting 47.1.
Man, fuck you. Not you, them.
All right.
Sorry.
As the prevailing defendant, and basically the thought behind it was what? It was noble, like the Me Too, the Me Too movement.
Yeah.
Was noble in purpose, wasn't it? Like, we could all agree.
I agree with that. Yeah, of course.
There are shitty people out there that SH people, and they take advantage of positions of influence and victimize people that don't deserve it. I think that 47.1, if you look at it in the context of the Tyler Perry lawsuit that I've been wanting to talk about, it makes a lot more sense in that scenario, because here's an actor that's probably got, I don't know, $50,000 in the bank, and he's trying to litigate against Tyler Perry, who was a multi-billionaire. And the disparity in positions of the two makes it such that 47.1 makes a lot of sense. Great, it's noble in purpose, but does it violate the Constitution? Because if you're stating that, as Lively is stating, that fees should be awarded at the earliest possible opportunity before the sides have the ability to present evidence in the case, well, what in the hell is that? That seems to me to run afoul of constitutional principles that we do not punish people with good faith claims. In other words, claims that are not frivolous. So regardless of what happened with Baldoni's cross complaint, he still has the ability to defend himself in this case. And if he has a good faith basis for defending himself, then he shouldn't be penalized on the pleadings, which is what they're asking him to do. That's not constitutional. And so,
well, that's what our friend Cassidy is here in the chat with us, says, I love that Ellen called it unconstitutional too. We've been saying that all along. And Cassidy loves Ellen, the writer of the response to this. So,
I did not pay attention to who wrote who wrote the document. No, but I've been saying that this was unconstitutional way back when. Like it didn't appear, like you cannot just insert treble damages, punitive damages, attorney fees and costs, because you don't prevail without certain findings. It just didn't seem to make a lot of constitutional sense. Other attorneys disagreed. I disagreed with them.
Yeah, I haven't heard from our friends Stuart and Keith in a long time.
Yeah, where have they been? I was going to ask you about that. How they, I assume that they've just been doing their thing.
I should just send them a message, because it's been like I said, I lost touch with a lot of people, not on purpose, but I guess I should try to touch base.
Or touch a base.
No, bro, I'm good there.
All right.
Just ask your mom.
Well, my mom's my mom's in the house. She's recovering.
Oh man, come on! Don't do this to me. Don't tell people that. Don't make this all serious, please.
Never mind then.
You just made me so guilty.
Just talk about my dad. How about just talk? All right, that would have been funnier and more apropos.
All right, man. Just go.
Anyway, so they're trying to make these points, misrepresenting in a televised interview. Who gives a shit about this? They're basically trying to say that their complaints were brought with malice, which there will never be an opportunity to make those findings because, and that's the other thing. So their cross complaint was just dismissed, and it was dismissed on pleading grounds, meaning not that there was a finding, a meritorious finding that they brought something with malice. They dismissed it because they failed to plead malice against Lively. That's what the judge said. And what I had openly wondered was, I wonder how that's going to affect, like, how are they even going to make the determination that they brought something in bad faith if it was defeated in the pleading stage without making that independent finding? So 47.1, it means well. It's just there's too many holes in it to be effective. Like, how do you even apply it? You can't apply it. They have to make certain findings with respect to the Wayfarer parties, which is the reason why they're bringing up all this stuff. But no jury is ever going to be able to even make a determination on these things. So are we relying on Judge Lyman's interpretation of it? Because that doesn't seem to be constitutional.
Right.
Because you kicked it out of the pleading stage. To me, if you kick it out of the pleading stage without a meaningful opportunity to litigate it, then there shouldn't be any penalty for that. In other words, in order for 47.1 to be actionable, it just feels like a defamation claim should make it past the pleading stage in order to be actionable. And I don't even know if I'm making sense. I'm kind of like spinning my wheels here, just thinking out loud as I'm considering these holes in the argument. But anyway, moving on. They talk about the Wayfarer parties openly discussing their intent to retaliate, and that's more Sauerett stuff, I think it was. $100 million to ruin the lives. Who gives a shit? Neither here nor there. Seriously, there's not a jury that's going to determine the context.
Oh yeah, the footnote there was where I think a lot of the kind of important context was to Mr. Sarwitz's counsel confirmed that his client is prepared to spend whatever necessary to defend Baldoni, Wayfarer Studios, and himself. I'm like, dude, I'm looking at that quote, and I'm like, what on earth is retaliatory about that? It's not like going on the offense. It's not attacking you. It's just, I will do whatever to defend myself, my friend, and my studio, our business.
Well, I mean, that's one way to characterize it. So they've offered their characterization of that quote without offering any context, and we don't have a jury to determine what the context is. So, I mean, that's nice interpretation, but I don't get to hear from either side. I don't get to speak to Sarowitz about that. So are we going to litigate that issue? Is it going to be an independent finding, or should it be something that's decided in a jury? But guess what? We can't, because dismissed at the pleadings. And you know what? I think that the Wayfarer parties should be credited with not, because they didn't really oppose the motion to strike. They just kind of let it go. No, it's not that. No, they opposed it. They just decided not to amend it. So deciding not to amend it, there should be some credit there. It's like, you know what? We're not going to do this.
We're talking about the dismissal, or?
Yeah, the dismissal of Baldoni's complaints. When they had the opportunity to write an amended and then they didn't.
Yeah.
Well, actually, not even, no, because they struck everything except for like a couple of causes of action.
There were a couple of causes, but then, Brian went on TV or whatever, or some stream or something, like pretty soon after that, and said they were gonna amend, and then they didn't. So that was a whole thing, and I don't know. It doesn't really matter at this point.
By the way, you could tell I'm rusty on this case. I haven't talked about it in months, and so I'm just trying to remember these facts. Anyway, I'm moving on with this. Inflammatory stuff on TMZ. I think that's what you were talking about.
That doesn't matter, though, does it?
No, who gives a shit is my point.
In the context
his comments were not. Yeah, the party's conduct should be irrelevant, because 47.1 hinges on a pled defamation case against Lively.
I feel like they just can't. They're just throwing as much shit in here as they can to make it seem like she's a victim of some kind, which hasn't been proven in any way, shape, or form, but that she's a victim of some kind to make her seem more sympathetic and to kind of make people maybe overlook the fact that she's inconsistent in a lot of ways.
Well, I understand what they're doing. What they're doing is they're trying to speak to the language of 47.1. It's designed to protect victims from being bullied by their SHers. And these SHers have bullied her, not just in the pleadings, but in media, on the docket, and they're just trying to just lead the judge down that path. That's what they're trying to do. They're trying to equate everything and throw it in, even though it's not in the pleadings, whatever. So, I mean, I sort of get that, but to me, it's irrelevant as it relates to 47.1. Retaliation, the Wayfarer parties filed a retaliatory defamation suit that was then stricken and then dropped. They made this lawsuit with no legal purpose whatsoever for this website. They're allowed to do that.
It's their legal. There's two documents on there, two legal documents on there, and that's it. There's nothing else on that website.
Yeah, and they are allowed to put stuff on there.
Well, she's well aware too of like litigation privilege and stuff like that. So I don't know why she's whining so much about it.
Right. They're talking about successful. So she was successful in her motion. This is the most relevant portion of it. To dismiss all claims, Lively argued that her allegedly defamatory statements were communications made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. Thereafter, on April 23rd, Lively served Mr. Sarowitz, Heath, Nathan, the Wayfarer parties, demanding that, among other things, they withdraw their civil extortion claims, the Rule 11 stuff, safe harbor stuff, and all those kinds of things. On May 19th, Lively files a motion for sanctions under Federal Rule 11, and in response to Ms. Lively's Rule 11 motion, plaintiffs did not even attempt to stand behind their claims on the merits. Instead, they argued, in essence, that the court should ignore the requirements imposed by Rule 11, that parties and counsel submit pleadings that are brought in good faith, and instead merely dismiss any deficient claims under Federal Rule of Civil Procedure 12b-6. Right. And then the court grants the motion to dismiss first amended, and then they were given instructions on how to amend it again. They can only bring certain causes of action. So they said, you know what? Screw it. We'll just focus on defense.
Yep.
That's how it went. So I remember all of that. There's some bullet points here. The parties failed to allege actual malice on the part of the New York Times. The court held CRD complaint.
Congrats.
Whatever.
What the fuck does that have to do with you?
They restate some stuff. This implies that Baldoni and Nathan at least considered spreading a negative story regarding. Fuck off with that.
I mean, I've considered at one time or another running over some terrible people with my car, but I didn't do it. You know. So who gives a shit?
Jesus. It's just not relevant to the 47 point. I mean, look, if you want to plead that at trial, then I think you should. If you just litigate the points, litigate the issues, then maybe amend your complaints to allege other things that would make 47.1 stick. But this awarding of 47.1 attorney fees without having to litigate or prove on the merits their claims is kind of silly. They continue with Mr. Friedman as their mouthpiece. They have made incessant statements in the press, misrepresenting the nature of their claims, attacking Miss Lively personally. They were mean to her. I hurt her feelings.
Vroom vroom, bitch.
All right, so this is what they say. California enacted 47.1 to clarify.
Really meet myself.
Oh my God. And codify existing law in direct response to repeated attacks upon individuals who report sexual harassment, and to provide a strong remedy to disincentivize retaliatory litigation, curb a pervasive culture of sexual assault and harassment, and provide significant remedies for successful defendants in defamation claims. And so it's a brand new statute. When was it? I think it was enacted in 2023, was it not?
I honestly can't remember.
There hasn't been any case law to give direction, and there's way too many holes in it to really know what to do with it. And so the question is, does it violate the Constitution? And we'll get into that when the Wayfarer parties start making their arguments, and you'll start seeing why. It's ridiculous to have this 47.1 statute and award attorney fees now, because Lively has no ability to meet the standard for which to even be awarded fees, because she has to prove that her claims were reasonable and that they were done without malice. And that just so happens to be Justin's main defense, is that they were unreasonable and made maliciously.
Right.
That's it. And so she wants fees awarded on the basis like, no, whatever, their case was dismissed. I shouldn't have to prove anything. They lost, and so therefore give me my fees. That shouldn't be how this works. I skipped over all this stuff because who cares?
Okay, fair enough.
Section 48A defines actual malice as a state of mind arising from hatred or ill will toward the plaintiff, and clarifies that a good faith belief on the part of the defendant in the truth of the libelous publication at the time it is published shall not constitute actual malice. So they're trying to defend based on statutory grounds. Still, good. I mean, good for them on citing that statute, but Baldoni has the right to frame it in the way that he wants to frame it.
Right.
Is the point. Courts applying the actual malice standard outside the context of Civil Code 48. I thought they were going to make a big point there. They just quoted something in quotation mark, explaining that the actual malice standard is focused on the subjective attitude of the publisher and therefore requires the plaintiff to allege that the defamatory statement was made with knowledge that it was a false, or with reckless disregard of whether it was false or not. See, the problem is that Baldoni is going to get her on the stand,
right?
And then they're going to bring up all of these motives that she would have had to make malicious statements, where they would have had the ability, or why she would have had motive to make these SH claims to maybe smear his good name, or maybe move him out of the way so that they could take over the movie and turn it into a franchise, into a $1 billion industry, and not just this one movie, maybe make 3, 4, 5, 8 of them.
Mm-hmm.
They have evidence that she's been plotting this for years, and they were going to use that to impeach her based on essentially her motives. And so if the jury gets to consider that or not, I think is the question. The jury should be able to consider whatever evidence that Baldoni is going to use to demonstrate that, yeah, she's lying when she says it was without malice. It was absolutely with malice, because there was a direct, now look, there's not a cross complaint to do that. So the way they're going to have to go about that is essentially by impeachment evidence. Anyway, we're getting in the weeds with this. The point is, we can't just take her word for it. There's just way too much out there without the benefit of a trial to just award her stuff before trial. It's ridiculous. And then continuing on with this, am I making sense or am I rambling? I feel like I'm rambling.
No, you're good. You're good. I just we haven't heard from you in a while, so I'm just enjoying the listening. So.
Oh.
Yeah, you're fine. Don't worry. It's no problem.
Lively has a reasonable basis to file her complaints. That's kind of the weakest argument that she has, or the most difficult that she's going to have to hurdle that she's going to have to climb. In other words, the privilege under 47.1 attaches regardless of whether a complaint is ever filed and no matter to whom the communication is published. As the California legislature explained, the protections would apply to individuals who, after relaying any factual statement, whether in the form of a formal complaint or a statement outside of a formal proceeding, such as to a media outlet, are sued for defamation. It is self-evident that Lively had a more than reasonable basis to report her workplace concerns during production and to file her complaints both with the CRD and this court, and the FAC provide no plausible basis to conclude otherwise. I would argue that the FAC gives rise to a question of whether or not there was a reasonable basis. She makes her claims, and then there was an answer. The answer wasn't stricken, and the answer calls into question directly the reasonableness of her claims. And I think that is for a jury to decide. You can't just ask Judge Lyman, based on these stupid arguments that are not supported in evidence, that is basically their characterization of how they interpret the pleadings, to make a determination on a reasonable basis or not, and then award treble damages because of it. It's just not constitutional.
No, I mean, it seems pretty fucked up. Just as people who have basic understanding of what's going on here, it seems, I think, pretty terrible. There could be a lot of people hurt by this. At the same time, it's I know they're supposed to try to protect people with this law, and that's the purpose of it, but also you think about the type of person who might get hurt by it, and it's just kind of terrible also. So all around, I have kind of a negative feeling about it.
Yeah. No, I agree with you. It's, again, I look at the Tyler Perry case, 47.1 makes a lot of sense in that scenario. Number one, they're all California residents. But number two, that's exactly the scenario, the situation. The person is up here, all the resources in the world is going to be sued for defamation, to the gills. And so let's disincentivize him from doing that. And, it makes sense in that context. But in this context, she's a New York resident.
Yeah.
All the conduct took place in New York.
New Jersey. A lot of it was in New Jersey because of the filming.
But outside of California.
Yeah.
Wayfarer has a headquarters in California, but the conduct took place, which is why she's able to file the CRD, but the conduct and the parties reside out of state. And so there was no reason for her to file a CRD, but for trying to take advantage of 47.1.
Yeah. Right.
And the question of whether or not they're going to be able to do that, it's a jurisdictional issue that 47.1 is silent on, which is, to me, a huge hurdle for them and something that Judge Lyman really should consider.
Right.
Why are you meddling with California law? This shouldn't be his call. And honestly, I think that the jurisdiction, if they are going to employ California law, then this issue should be litigated in California. Why Judge Lyman would have a say in the matter is beyond me.
Yeah.
Anyway, I highlighted this for some reason. As set forth, the Wayfarer parties with and through their lead attorney, Mr. Friedman, brought and maintained claims. Oh, shut up. All right.
Okay.
The point here, the court should set a schedule for promptly quantifying these monetary awards. As such, the court should set a schedule for promptly quantifying the monetary award to which Miss Lively is entitled well in advance of the March 2026 trial on her case pursuant to 54D2C And then in these circumstances, Rule 54D provides the appropriate procedure for deciding questions of liability for harms. Okay. And then when a motion relies on facts outside of the record, the court may hear the matter on affidavits or may hear it wholly on part on oral testimony or on depositions. Yeah, that's true, but much of it is not off of the record, though, is the point.
Yeah.
Underline section 47.1 by making the statute's remedies available to Miss Lively at the earliest stage in the litigation. Miss Lively should not be delayed or required to prevail on the claims in her own case to obtain damages to which she is entitled under section 47.1 today. I highlighted that in red because it is the most ridiculous sentence in this entire thing.
Yeah, that's fucking crazy.
Let's read that again. Miss Lively should not be required to prevail on the claims in her own case to obtain damages that she applied for. Why?
What?
I didn't write it. They wrote it.
I'm sorry, I just got dumber the second time. So. Okay.
If it hinges, excuse me, if her claim hinges on whether or not she brought this claim maliciously and had a reasonable basis, she should have to prove those two things. She is the plaintiff. She's not defending claims. She brought these claims. She should have to prove those claims and not just be awarded them because of a motion to dismiss, which necessarily takes the prospect of proving all the things that she needs to prove off the table, which is interesting.
Mm-hmm.
So now what? Anyway, let's get to the now what. So that's their motion. Let's get to the other one.
I don't know if you saw they were arguing about keeping the thing sealed about Sarowitz, because the attorneys for Wayfarer say that if they're going to put that out there, basically there's no reason to keep it sealed because they can just keep the name redacted, and it's only fair to Steve Sarowitz for the entire conversation and context to be like, not sealed, because otherwise it just makes him look bad and it's not really, showing the full situation. So I guess apparently some stuff was said that is going to be important in context, but we can't see it right now. And Blake wants it permanently sealed and the Wayfarer parties do not. So, and I guess the person who recorded him saying that did so without his consent. And if that happened in California, I guess that's a two-party consent state. I don't know if that's ever going to be a problem.
Well, first of all, there's lots of cases like that. Yeah, that would be considered a surreptitious recording. You can't just, like, for example, you're at a sporting event with somebody and you guys are talking shit. You guys are like, BAC 0.15 because you got Ubers and everybody's being responsible, but you're having a good time.
Low, but yeah, okay.
Right. And you just start saying stuff about cases that you may or may not be involved in, and everybody's got liquid courage at 0.15. And so he just starts talking like, I will defend my company the same way that Israel has guarded against Hamas. And, these ridiculous, outlandish statements, right? That you wouldn't say if you were sober. That's what it sounds like. It sounds like they recorded him in a moment like that.
I have no idea. He's a Baha'i. I know they weren't they don't believe in drinking and stuff like that, so they don't drink. So it wouldn't have been like a drunken thing, but maybe in a heated moment, you know what I mean?
Or maybe just he thought you're out with friends and you're talking shit, and you thought that you're safe, and somebody's got a tape recorder.
Right, exactly.
And then that's called a surreptitious recording. That's not legal in California. It's not admissible evidence.
Well, they try to say that Andy did that to their receptionist, which is funny to me. And then they're trying to use something from an illegal recording as evidence. Okay.
You talking about our Andy Signor?
Yeah, man. Back when all that was happening with the subpoena stuff, and he recorded the conversation. This conversation is recorded. He said that to the receptionist before she proceeded to talk.
Yeah, that was the first thing he's out of his mouth. They're talking about that recording? That's ridiculous.
Yeah, that was a while ago.
It was a while ago. That was back in June.
It's been a couple months, man. I think it was July.
So let's get into this before we bore everybody. Draconian relief. I agree. Draconian. Oh, why is it green?
I don't know. You picked green, dude.
All right. So they start off plaintiff Lively seeking draconian relief under 47.1. That's one way to characterize it. I've used the word draconian before to describe 47.1. Lively, the statute, and its legislative history are silent on whether these remedies are available for dismissal of a consolidated complaint. This inquiry turns on Lively's motives. Exactly, right? Just like we said. Twit, whether her complaints of sexual harassment were made with malice and with a reasonable basis. Factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No trier of fact has made these factual determinations, which are central to the Wayfarer party's defense and will be ultimately determined in the still pending main action. Although Lively contends that to be effective, the remedy should be imposed at an early stage of litigation, which makes no effing sense. Neither the statutory language nor its legislative history, of which there is none, address the dismissal of a consolidated complaint before the complainant's sexual harassment claims are tried in the main action.
Yep.
And then just skipping ahead, in the context of 47.1 of the complainant's motives and intent would divest a defendant of his rights to a defense at trial or by summary adjudication based on admissible evidence. Lively, in fact, does not directly address the key issues of her motive and intent. And isn't that the problem?
Yep.
Like, so you have to prove these two things, and you're not even going to address it?
I don't think anybody should ever be awarded hundreds of millions of dollars without at least, showing a reasonable basis for that.
I mean, I could just see so many different ways that could be abused.
Right, and only by, rich people. Really.
Yeah, they continue. Whether Lively had a reasonable basis for her sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed Wayfarer party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer party spread negative stories about Lively. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Reynolds, Sloan, or the Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her sexual harassment claims, which very well might have been the reason why they just said, you know what, F it, let's just drop it and play straight up defense and turn our defense into offense, which makes more and more sense as time goes on. They continue with this stuff. I highlighted these bullet points because they are like the big things. But for context, notwithstanding Lively exhaustive rehashing of the full breadth of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in 47.1. And then they say Lively's motion should be denied because, among other things, fails to show that 47.1 has extraterritorial application. That just means that it can be applied to residents of other states for conduct that applied in other states. In other words, why should people from Wyoming just file something in California and be protected under California's 47.1 statute that seems to violate federal laws? It just seems like you shouldn't be able to subject people in other states to laws from states that they don't live in.
Well, that's nuts. Yeah. That does seem really nuts.
Anyway, they have a more educational discussion about it than what I just provided.
No, you're good. You're good.
Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under 47.1. Here's the two big ones. No trier of fact is found based on admissible evidence that Lively's sexual harassment claim were asserted without malice and with a reasonable basis. No trier of fact. None. Lively fails to show, and no trier of fact is found, clear and convincing evidence, the malice required for punitive damages as required by Section 3294, and plaintiff has not proven, and no trier of fact is found, the actual compensatory damages required as a basis to calculate treble or punitive damages. In other words,
I remember, go ahead, you first.
Malice is really effing hard to prove. So we're just going to give that to her?
Yeah.
So Baldoni filed this with malicious intent, and we're just going to give that to her when the standard is clear and convincing evidence, which is pretty close to beyond a reasonable doubt.
Well, when she, like, her response right after the dismissal, I remember, because it was very fucking frustrating, was she put out that post about how his case was dismissed. It was a retaliatory lawsuit, and how all those organizations had stood up for her and made it happen because she's a victim and all this stuff. And like, it was just very untrue when you looked at the actual ruling and why the claims were dismissed. So I feel like you can get away with that when you're talking to people on Instagram,
Yeah.
but maybe not with the federal judge. I don't think it's going to happen.
Right. And so their point is, I mean, it seems so obvious when they bullet point it like this. 47.1 appears to have, it appears that it requires certain factual findings. And the factual findings that it requires appear to be within the purview of a jury, since a jury trial has been requested, and should not be in the hands of a federal judge who hasn't seen any of the evidence, and certainly not before trial. What is that about?
No, because any Blake Lively's claims, in my opinion, they have a far reach because of who she is, but they end when the gossip ends and you have to start talking about the facts of the case. It's like,
yeah, I mean, yeah, no, exactly. Here's the Nora Pennington arguments that I've been making for months. As a preliminary matter, Lively does not address the constitutional concerns and conflicts raised by 47.1's express language, conflicts with the right to free speech and petition guaranteed by the First Amendment of the U.S. Constitution, nor Pennington Doctrine, which provides that those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. In other words, you may bring a non-frivolous complaint to court without fear of being automatically punished if it fails to succeed. That doesn't insulate you from other damages that might arise after a finding of fact. But if you bring a good faith complaint, you don't get to be automatically punished for that because it runs afoul of Nora Pennington, which highlights how that is a violation of the First Amendment.
Yeah.
By imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith, Section 47.1 appears to trespass on the Nora Pennington immunity doctrine. Creates an absolute to what? Second, plaintiff fails to address how 47.1 can be reconciled with 47B, which, consistent with the right to petition, creates an absolute bar to any defamation claim based on statements made in connection with the judicial proceeding. Yeah, same principle. Anyway, that's really the big constitutional issue here. And then there's third, a defamation claim is dismissed at the pleading stage. Plaintiff fails to explain how 47.1 should or can be applied when, as here, a defamation claim is dismissed at the pleading stage before the dispositive factual issues of whether plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. And then there's case law to that, and they talk about why that's ridiculous. Plethora, I hate that word plethora, a plethora of serious constitutional issues. Oh, shut
I hate the word mealy, but here we are.
Oh, no, mealy, I've adopted that one. I like that one.
Good Lord.
You could think, wasn't it Cassidy that came up with mealy?
No, it was you, bro, I thought.
No, I got it from her. I got it from her when you were live with her once, and she was talking about something. Mealy?
Cassidy, don't make me blame you for this.
It was Mealy's fault. It was Cassidy's fault. She said mealy, and it was like, yes.
God damn it.
Mealy.
Wait, is that when we were talking about the apples?
That's exactly when it was. She was talking about apples, and she's talking about a mealy apple. And then I was in the comments like, a mealy cunt. And it's like,
yeah, dude, I hate you.
I don't know why I said that, but it came out of my comments. I was trolling your comments.
I thought you were going to say it came out of your cunt, but all right.
Anyway, this is the extraterritoriality thing that you were confused with. It just this is all it means. The threshold question is whether these California statutes have extraterritorial application, whereas here, plaintiff is a resident of New York, and the underlying conduct occurred in New York and New Jersey. The California legislature knows how to create exceptions when that is its intent. And when a statute gives no clear indication of an extraterritorial application, it has none. That's a huge hurdle to get over. So they're basically stating that the case law, Kybel, citing Morrison, these other cases, Sullivan, Morrison again, Ward v. United States, all these cases say that if a state statute is silent as to extraterritorial application, then there is none. And that kind of defeats the argument before it ever gets off the ground. So this is huge, which is why I have this big circle here, because it was like the biggest point. Like this is if the judge agrees and they don't have anything to counter these cases, then 47.1 should not be applied in this case.
Right.
If I'm the judge, I'm like, well, counsel, I have 5 cases here that say that if a statute is silent as to extraterritorial application, then it doesn't exist. What say you? Give me one instance where that's not true. And if they can't do it, I think you got to dismiss the 47.1 claim.
Right.
Am I making sense when I'm saying that? Like, do you understand? Like, the blue part here, Jesus. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history.
What would be an example of the second part?
What second part? This blue.
Unless such intention is clearly expressed.
Oh, I mean, like the words are in the statutes.
Okay. Yeah.
Like, for example, 47.1 says, this statute shall apply or have extraterritorial application should anybody from an outside state avail themselves in any capacity in the state of California.
Right.
Meaning we're expanding 47.1's application to conduct and residence outside of the state of California if they have some minimal tie to California. For example, Wayfarer has headquarters in California. It would have to explicitly state that, but it doesn't say anything like that.
Yeah.
That's it. Lively does not point to express language in 47.1 or any portion of the legislative history that even hints at an intent that the statute have extraterritorial application, because it has no legislative history.
Right. Yeah.
In fact, 47.1 does not include any affirmation indication that it was intended to apply to conduct outside of California. And then they cite these cases. Absent the express or implied showing of an intent of extraterritoriality, Lively must establish a substantial connection between the situs of the legally relevant conduct and California. She may be able to do that. I don't know. I'll let them make that argument. But if that's what they have, just some substantial conduct, it seems to me that the only tie-in is her CRD complaint, which she was never barred, which everybody could file anyone could file a CRD complaint.
Yeah.
Which is what she did. Which would be like a bare minimum of contact with California. In other words, 47.1, here's an example. If an out-of-state person files a CRD complaint that is accepted by the CRD, then they will have the ability to avail themselves of this statute. Even if the conduct took place outside of the state, and even if the parties reside outside of the state. That could be an example of language that would be included if that's what they intended to do. But they haven't. Does that make sense?
Yeah.
Okay. Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court on the underlying sexual harassment claim, which would give rise to the privilege she seeks to invoke. What? Oh, neither Lively's complaint. I hate when I do that. Neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the complaint and stuff. All right. They're just arguing more that they haven't made the substantial whatever. There's no factual findings that Lively's claims were asserted without malice and with a reasonable basis. The jury must resolve this. I should have highlighted this in red. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. Plaintiff does not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case, Lively's harassment claims. Should this court prematurely decide that Lively's sexual harassment claims were asserted without malice and with a reasonable basis? And then it just continues on. This entire heading, honestly, should be adopted. She hasn't proven that she's entitled to punitive damages.
Right.
That's a triable issue. End of story. Whether a defendant acted with malice is an issue of fact for the jury. And then, this is what I was talking about, clear and convincing evidence. The clear and convincing standard presents a heavy burden for far in excess of the preponderance sufficient for most civil litigation. The best way I could explain clear and convincing evidence is it's as close to beyond a reasonable doubt as you get.
Right, yeah.
Without being beyond a reasonable doubt. Preponderance of the evidence is like 51% or greater. Clear and convincing evidence would be like 75% or greater. And these numbers mean nothing. I'm just...
I think that, it just, even listening to you talk about this, I'm like, I don't understand at all how it would be possible or right in any way to rule on this before the jury trial.
I 100% agree.
And she's like, we need this right away. We need it as soon as possible. I'm like, what the fuck are you doing to people who actually need this law right now?
This is one thing that myself and Ask Two lawyers agreed on. It's like, how do you make these findings without going through a trial?
That makes no sense at all.
Because we were wondering, like, how would they even be able to award her damages before the trial if they got to make these factual findings? And then we were coming up with scenarios like maybe they have like two trials, like a miniature trial after she wins her first trial. Or that, we're saying things like that because we didn't get it either. And so, anyway, plaintiff simply ignores the requirements of malice be proven stuff. All right, that was it. Yeah, that was it. And so, let me get rid of this.
I got it.
Boom.
There you go.
Oh, wait, it's asking me if I want to save stuff. Do I want to save anything? Well, I saved it anyway. Yeah, so that is... There's more holes in 47.1 than I possibly imagined, which is the reason why everybody's so confused about it. Because if you try to put it into practice, if you try to apply it to real life, it just, how do you do this? Which just tells me that 47.1 is incomplete. It needs further revisions.
Yeah.
I don't know what else to say. I think that 47.1 should not be ruled on at all until after the trial. I think that should be a separate hearing after.
I cannot imagine a world where like people actually believe that being ruled on before the jury trial is just. Like, I don't understand that at all. That's fucking crazy.
Well, it wouldn't be just, and it wouldn't be constitutional.
No.
I mean, if you're applying, like, you can't apply statutory automatic fees without findings of fact in 47.1. Look, they're statutory fees, sure. They impose treble damages and other things, but there's still factual thresholds that you have to overcome in order for that to apply. And so you should be forced to apply those factual standards before getting awarded anything. How could the judge even begin to calculate damages without going through a trial?
Yeah.
It's ridiculous. Ridiculous.
No, it's fucking crazy. Somebody asked here, and I think we were going to talk about this at the end for a little bit. Can you and Omar review the Vanzan of it all? So the Vanzan thing, I know you hadn't had time to read that.
I haven't had, I have not read
all of it because all of that started last night. So I've read all of it. Wayfarer filed a motion to compel Vanzan because there were like some argument over like the Vanzan, they don't want to provide the name of the witness that's going to be deposed on Tuesday in 4 days. They still haven't provided the name of the person who's going to be deposed. And also they're refusing to, I guess, testify to stuff that happened before the Vanzan lawsuit was filed, which is important because, of course, Jennifer Abel says that the stuff was taken off her phone and they sent it to Blake from Stephanie Jones before the Vanzan lawsuit was filed. So they would need to know their relationship to Stephanie Jones before all that happened. So that's what started the argument.
Have they ruled on that motion yet?
He did. He denied it. But he denied it because they went back and forth in a meet and confer for a couple of issues, and they narrowed down a couple of the topics that Vanzan was like, we're not answering all that. They narrowed it down. They agreed on the topics as they were narrowed. They didn't agree on the timeline. Like, they didn't agree on the relevant time, the time period before the lawsuit was filed, from like the couple of months before until it was filed. So they, I guess, filed a motion to compel for that. Vanzan comes back and says, basically, you never met and conferred with us about this issue, this one issue, which was the timing of it, which, if you look at the emails, it seems to be true that they didn't specifically address the time. Kevin Fritz for the Wayfarer parties writes back and says, you attempted to bury this like one thing in your list of objections. And I don't know if I'm explaining this the best, but
no, I hate when lawyers make that argument. You buried this. It was you put it in there, but I couldn't see it.
So they made that argument. And then Vanzan, wrote back and said, you never met and conferred with us about this specific issue, the timing issue or whatever. And I guess Vanzan ultimately said they will testify to the time period that they wanted. But they went through this whole thing first. So I guess some people are saying that it was maybe a strategic thing to get that on the record. I don't know what that really means, to be honest.
Well, to be honest, I would have to read what they're talking about, because trying to make that kind of determination off of your summary of it would be irresponsible. But
I would agree with that in any circumstance. So that's fine.
I did plan to read the Vanzan stuff. I just ran out of time because I got too heated reading this 47-1 stuff.
Oh yeah, no, I get it. I get it.
I was really just going to skim over it because I feel like I already knew the issues, but I was like, yeah, I got really excited, and so
basically he denies the motion to compel Vanzan and says that they can file a separate document asking for legal fees because of it. And I guess it was at first when I read all that, and I hadn't read it beforehand. I was reading it live as it came out, like I usually do. So I was like, okay, of course he, denied it or whatever. And I was just like being pissed off, like I usually am when I'm reading stuff in real time. But afterwards, I kind of realized, they actually really didn't bring up the time issue. I don't know why they didn't bring up that issue before.
They just probably forgot. I don't know. I don't know if that's a huge deal, but it's certainly relevant. I mean, everything, number one, whether or not it was a sham corporation or not, which I think we all kind of know it is.
Yeah, that's not really the issue at hand, I guess. The issue was just
communications, right, with Abel.
Right. The communications with Abel, they've agreed to testify to their relationship with Stephanie Jones, I think, and to Jen Abel's counterclaims, but they only were agreeing to it for a certain period where like that excluded the couple of months before the Vanzan lawsuit was filed. And
that's the good stuff. We need that shit.
Right.
You can't
exactly.
exclude the first couple months before the Vanzan. No, man.
So after Wayfarer filed this motion to compel, they then agreed, I guess, to do that. So
that's probably why
I guess they were trying to give him a push. Yeah. Right.
Yeah. There's nothing really extraordinary there. It seems like everything's kind of going according to plan. They're going to get what they need.
Yeah. So it just kind of it looked like, I think, to a lot of people who've been following along and we're not like lawyers or anything like that. The only reason I've had this thought is because I watched some other lawyers talk about it, but like was that they just asked for this thing for Vanzan, it was denied, and so it was kind of hard to understand at first, like why he denied that so quickly and all that, and why they would be able to ask for attorney's fees. And then I kind of started to understand, like, they didn't do the meet and confer and then wait 48 hours.
Sure.
I get it, but at the same time there might have been some benefit to that, but I don't totally understand. I guess I just wanted to push that point with the time, because the deposition is, like I said, Tuesday, so they don't have a lot of time, and they wanted to get them to agree to testify to that time period. So,
well, I'll tell you what, it doesn't sound like anything remarkable. It doesn't sound like anybody's really won or lost anything yet, and so that's kind of a wait and see. But I'm going to take a deeper look into those documents and see if there's anything there. But it doesn't sound like anything earth-shattering.
Nah.
So far, just a lot of boring discovery procedure stuff.
I mean, it would kind of suck if they had to pay the attorney's fees for the Vanzan broom closet for that exchange. But at the same time, it seems that they got what they wanted out of it.
Yeah, I'm sure that is what it is. But Lauren, I think I'm going to dip out at this point at exactly 60 minutes.
All right, man.
So, hey, I missed you guys. I missed all you guys. I missed the Blake Lively crowd. I missed commenting on this case.
Yeah, people ask about you all the time.
Oh, well, I've been busy. So,
okay, well, if you don't start coming back at regular intervals, I'm going to start telling people you're dead just to cause problems.
All right. Well, I'll tell you what. We'll start.
He was one of the people I ran over with my car, guys.
Because of excessive use of the word muley. She didn't like
it. He wouldn't stop. I had to stop him.
We'll start streaming more regularly.
Oh, wait. We got to read these 3 super chats. Hang on.
Oh, let's do them. I
love kitties. 73. Thank you for the $2 super sticker. I appreciate you. Good bitchin' lady. Sounds like my type. Thank you for the $10 for Lauren's new car fund. And Omar's soothing voice. Thank you very much. Man. And Omar, this is for you here, man.
All right. What's up, Ricardo? Hey, you been missed. Kick dingus with the yes, ma'am. Or yes, sir.
You leave his vagina alone.
All right. I intended to, but.
All right, guys. Thanks for watching. We'll see you guys later.
I love you guys. Take care.
Bye.
Bye-bye.